Good afternoon. I'm Banaz Mansouri, Senior Attorney with the Unemployment Law Project. The Unemployment Law Project has been around since 1984. We are the only freestanding legal aid office in the country solely dedicated to unemployment. The Unemployment Law Project provides free legal advice and representation at hearings to people in Washington state who have been denied unemployment benefits or whose award of benefits is being challenged. We're here today with our weekly webinar, which occurs every Monday at noon. The purpose of today's webinar is to share the latest news on unemployment benefits, to provide information and updates about a lawsuit we filed, and to answer your questions. We'll share some commonly asked questions and answers, and we'll also be monitoring your questions in the chat box today. I'd like to introduce our speakers today. We have the Executive Director with the Unemployment Law Project, John Tierpak, and normally we have our Staff Attorney and Policy Director, Ann Paxton, with us. She is off today, so I will be serving in her place. And I will turn it over to myself to get started. Okay. All right. Lost Wages Assistance Program. Here's an update on the Lost Wages Assistance Program. The LWA was authorized through a presidential memorandum signed on August 8th, and the funds are retroactive for unemployment benefit week ending August 1st. LWA was an attempt to extend the $600 per week pandemic unemployment compensation that expired on July 31st. Congress has since deadlocked over the extension of the PUC, which the House of Representatives has passed and which a weaker replacement by the Senate has failed to move things forward. The Employment Security Department will start processing the payments of the Lost Wages Assistance Program on Monday, September 21st. Eligible claimants will receive the money in their accounts as soon as their bank processes the payment. ESD estimates 2 to 3 days wait time. Washington's application for the short-term federal program was approved on August 24th. This will provide an additional $300 per week for a limited time to those people who are eligible to receive lost wages assistance. And primarily, those are claimants who lost work due to disruptions from COVID-19 and are receiving unemployment benefits. So that's an important distinction, and I want to highlight it again. Under the Lost Wages Assistance Program, claimants who may be eligible to receive these benefits must certify every week that they are unemployed or partially unemployed due to disruptions caused by COVID-19. With more than, we estimate that the Lost Wages Assistance Program will total more than $450 million to families and individuals in Washington state. The benefit, again, is currently for a limited time. It's only for a 3-week period beginning July 26th through August 15th. And not everyone who is filing for unemployment will be eligible. The policy director at the Employment Security Department has told our staff at ULP that the state has approval for an additional 2 weeks, which would extend the LWA program for a total of 5 weeks. In Washington state, claimants have been alerted to answer certification in their e-services account starting September 8th. And you need to respond by September 20th, 2020 in order to receive payments retroactive back to August under LWA. If you prefer to have correspondence with ESD in writing, that is also an option, but do please keep in mind the deadline of September 20th, 2020. Okay, and as you may know, as Ann has mentioned before, the Lost Wages Assistance funding stems from FEMA funding. So it is not general funding. There is, that funding can be utilized for any FEMA-related emergencies. And our understanding is that Texas has already announced that it has offered its last WA payment after only being able to provide 6 weeks of aid. So a couple of questions, Q&As related to LWA. Will individuals who have already been provided their underlying benefits for the weeks ending August 1st receive LWA retroactively? Our understanding from ESD is that yes, they will. LWA is payable retroactive to eligible claimants beginning with the week ending August 1st. However, if an individual becomes unemployed after the week ending August 21st, they may only receive LWA for weeks in which they qualify, meaning they were unemployed due to an eligible reason related to COVID-19. Another question is, can lost wages assistance payments be used to repay a past debt of unemployment benefits, usually known as an overpayment, or be deducted for child support payments? And the answer here is no. An offset of lost wages assistance payments other than for tax withholding are not permitted. So the states may not offset your LWA payments for in traditional ESD UI overpayments or for child support debts. Another question that has come up is, if a determination of eligibility for a prior week of unemployment is not made until after the LWA term has expired, so that 2 to 5 week term that we're looking at right now, will the lost wages assistance be paid for that week? And the answer is the LWA program will terminate once one of the 4 termination provisions is met. Then no further lost wages assistance will be payable at that point. An individual whose eligibility status is determined after this end date is not entitled to lost wages assistance for the weeks of unemployment occurring before that date. That answer seems very confusing to me. So we will try to find additional information and post it in the chat related to the 4 termination provisions. I don't have further information on that right now, but we'll take a look on the ESD website to see what additional information we can provide for you there. All right, it is important to also note some additional dates. PUA was authorized by Congress and is available until December 31st. LWA is through the FEMA Disaster Relief Fund, and it will run out at an indeterminate amount of time. And I think the maximum time is going to be 5 weeks, but it could run out sooner. To get the first 3 weeks of benefits, you must get your LWA application in by September 20th. Okay. Brief update on the national unemployment picture. The number of people in the United States receiving an unemployment check each week is totaling around 29 million people as of late August. That accounts for about 19% of the US workforce. Roughly about 146 million people are now unemployed. Some economists are predicting that 30 million US job losses are stemming from the virus, and that is about 3 times the number of job losses that disappeared during the housing crash. The number of new claims or initial claims has remained stubbornly high, above 1 million after falling briefly in August. A huge number of layoffs is taking place, and that is receiving partially the blame for this increase in filings. Even with the $300 per week boost under the Lost Wages Assistance Program, the total benefit will be more than $1,000 short of covering modest expenses for a household every month. Economists warn that the loss of federal support could act as a brake on recovery. And to that, I would say it's important to make your voice heard, to contact your legislators, to vote in November. These are federal funds. It's a national systemic issue, and we can make effective change at the voting booths. All right, let's move on to an ESD update. Following Labor Day, ESD announced that payment processing was delayed by 2 to 3 days due to the holiday and slower than normal processing. So if you were traditionally receiving your weekly claim benefits and there was a slight delay after Labor Day or early September that you noticed, this is partly the reason why. If your claim was successful between March 8th and September 5th of this year, you had a 70% chance of being paid within 1 week. I don't know what that chance is for the remaining 30% or what that time frame looks like for the remaining 30%, but ESD tells us 70% of claimants are being paid within a week in these last 6 months. The average time to resolve claims with issues as of September 5th, ESD is reporting 6.3 weeks. And I'm taking that to mean their adjudication process. ESD reports the total claimants not currently receiving payments who are still awaiting resolution by ESD is 23,401. ULP estimates that approximately 30,000 appeals of denials are still waiting several months for a hearing date to be set before a judge. All right, moving on to the Seattle Times on September 6th, the editorial board posted a really great editorial, and there was a contributing quote by Ann Paxton, our ULP staff attorney and policy director. The editorial, which Erin is going to post in our chat link here shortly, highlights the problems that have persisted as ESD has continued to receive a record number of applications, transitioning its own workers to telework, boosting telecommunications infrastructure, and training about 1,200 new employees hired to supplement the pre-pandemic workforce of just 1,700 employees. The conclusions that the editorial board reached is the number of workers filing new claims for unemployment is still nearly 4 times the new claims applications received this same week 1 year ago. That's devastating. There's a quote from Commissioner Levine. The quote in the editorial that we want to highlight for you is, moving forward, Commissioner Levine must be more transparent about her department's challenges and limitations, and more assertive about demanding the resources she needs to meet this extraordinary demand. Very well said, editorial. We couldn't agree more. Lastly, let's move on to the PUA application. Oh, and pardon my typo in the PowerPoint right there. All right, some 2 frequently asked questions regarding PUA applications. If you file for PUA because of one of the COVID-19 related reasons described in the CARES Act, but you later have a different COVID-19 related reason applied to your situation, do you need to file a different application? The answer to that is from ESD. The claimant must prove the initial reason for their unemployment, partial unemployment, or inability or unavailability to work at the time of the initial PUA claim has been stated when they initially filed. PUA eligibility is determined each week. So the claimant must recertify every week on the continued claim that one of the listed reasons is COVID related, and they don't need to distinguish whether it was an existing or prior issue or it is a new related COVID issue. The second question we have related to PUA is, may a claimant who stops receiving PUA benefits reopen the PUA claim and resume benefits if they become unemployed again due to a qualifying COVID-19 reason? And the answer from ESD is yes, they can. A claimant may reopen their PUA claim and resume receiving benefits provided that they meet all of the eligibility requirements. So similar to a regular UI claim, if you're collecting benefits and you return to work and after some time you are again unemployed and want to seek benefits, you would reopen your existing claim and start filing for benefits. The same applies under the PUA. And again, one last thing to note is PUA was authorized by Congress and is available until December 31st. That is our general update, and I will turn it over to Erin for questions.
Absolutely. I just wanted to make a note that I did put the editorial in the chat, so you should be able to see that, everyone. And I also threw in a link that is addressing ESD's new PUA questions, so people can read through those. I don't actually have any questions in the chat, so if you guys have things that you'd like to address, now would be the time to pop those in.
Well, it might be a good time. It was mentioned earlier about an update on our writ in the Supreme Court. That is moving ahead. Many claims have been paid, but Unemployment Law Project is still receiving hundreds and hundreds of calls. So many people are waiting for hearings for months. Many people were cut off from benefits because when they did Operation 100%, they counted people who had not received any benefits at all in a certain period. So that was not counting people who were denied and who are waiting for hearings. It didn't count people who got benefits for a few weeks and were cut off. for no good reason, or people who filed after the goal dates of Operation 100%. So we are still getting calls. It's still an ongoing crisis. The Employment Security Department has stopped doing their weekly press conferences. They've declared victory, and it might be a good public relations campaign, but it's not really accurate in terms of the numbers of people, the tens of thousands of people who are still waiting for benefits. The writ is going ahead, and I want to say that the defense that Employment Security Department has been putting forth has focused on the fact that many people cited in the initial filings have now been resolved. So they're attempting to tell the courts that, you know, there's no current issues. So I put my name and email. Let's see. So I want to put my name and email to anyone. If you or people you know are still waiting for benefits or have problems and want to participate in that, please contact me individually. Also, we're still seeing you know, ongoing issues that need attention just in terms of individual advocacy. So feel free to contact the Unemployment Law Project. I am attempting to put my email, my name and email, and it is not working for some reason. I don't know if Aaron, if you can do that for me, but it's not being sent for some reason. There. Okay. If you could forward that. Also, just ongoing advocacy is needed in terms of contacting the governor's office and your state senator and representatives about whether it's an individual issue that you or someone you know has, or whether it's just advocacy for the overall problems with the system. And the website for the Washington State Legislature, where you can find your district, is leg.wa.gov. And also, I just want to reiterate the importance and what Vinaz has said about the importance of contacting our federal representatives, whether it be Congresswoman Jayapal, if you're in our region here in Seattle, or Senators Cantwell and Murray, about the importance of passing some sort of federal relief, some sort of federal supplement, because we're seeing a lot of people who were getting minimal amounts of benefits. Some people who were self-employed were approved very quickly, and all of their past income wasn't really considered, so they have a weekly benefit amount of maybe $200 or $300, which is very, very small if you think about what the cost of living is. So getting additional funds as a supplement is very, very important. We don't know what the political situation will be in the future, what Congress will look like months from now, but it's important to advocate the importance of it. I think that some people are treating the unemployment crisis as something that's in the past. There is a governor of a Western state who's not taking any supplemental funds for unemployed people, because the attitude or the position is our people are getting back to work. And it's still an ongoing crisis. I mean, even though unemployment's come down a lot, people are still underemployed. The statistics don't really show the whole problem, and the unemployment rate is still extremely high. We're talking about rates that we saw back in the Great Recession of 10 years ago. 10, 11, 12 years ago, and that recovery took a long time. So it's good to be engaged with your political leaders, whether it be state or federal. The governor's office should hear about the ongoing crisis. We are getting a lot of calls and questions about the pandemic, about the lost wages thing, and some people are getting very conflicting or odd messages about that, which isn't surprising. That seems to happen a lot with benefit programs like this. If you do have questions or get odd notices about it, please contact us individually, and we can help sort it out.
Okay, so I did pop some links in the chat that can direct you to your representatives, Governor Inslee, the AG, to file formal complaints, just like making your representatives aware of these issues and asking them to advocate for you. One question that we ran into is a very specific circumstance for this individual, but I think a common theme that could apply to all of us is there's a lot of people who are waiting for their hearings where they sent in an appeal a fair amount of time ago and it's just been pending, and they'd like to know if there's anything that they can do to expedite this process as they've been waiting for a fair hearing for a significant amount of time.
Well, with the problem with the appeals, the poor hearing office is getting thousands of calls of people waiting for their hearings. You can call the hearing office to check to make sure they don't have it, but the process unfortunately involves Employment Security Department sending the notice that they're sending the request for the hearing to Employment Security, to the hearing office, from Employment Security to the hearing office. And that has not happened. So it's good to check there first, but again, you can contact your state senator and representative about it. They need to push these claims forward, these appeals forward. I know that the Office of Hearings is hiring more people now, but they're still months or weeks behind, weeks and months behind on this. And also you can contact Oz or myself individually, and we can try to contact ESD to see if any progress can be made. One of the reasons for the delay is they are attempting to resolve some of these claims without a hearing, and that makes sense in many cases. People were denied because, for example, they allegedly did not provide their identification information, which in fact they already did, but an issue like that can be resolved very quickly without a hearing. There's no need for that, but there are still thousands behind. So I would urge both contacting Employment Security directly if you can, try that 800 number, contact your state senator and representatives, and also contact Unemployment Law Project.
That's great, John. I would also add along the lines of what you mentioned, ESD often is trying to resolve these issues through adjudication, so keeping them in-house at ESD before sending them over to the Office of Administrative Hearings, and sometimes they will have additional questions for claimants. So do check your SAW account, check your messages, check your emails, see if ESD has done any further work on your case and is asking any follow-up questions regarding prior employers or identification. And the most you can do is, if you can answer those, I think it might be helpful in moving your case forward. So just also keep an eye on your account messages from ESD.
Okay, so I have another question. It's from a substitute teacher, and they are wondering more specifics about the LWA. They believe that the application asked if they were currently unemployed if their hours were reduced to COVID, but they were unsure how to answer that because their hours are reduced more accurately by remote learning. So they answered yes, but they weren't entirely sure if that was considered unemployed due to the pandemic.
Well, I would say it's yes, because the whole COVID crisis has created the need for the remote learning. So I think that's a safe yes, that the unemployment or underemployment is clearly related to the COVID-19 crisis. Also, just I wanted to add something I wish I had added earlier about job search requirements. Normally, claimants have to, if they're not in a full referral union, be searching for work and making 3 contacts as well as being able and available. They suspended that rule in early March, and then it was going to, that suspension was going to end in August, and then it got postponed. So now it's set to end October 1st, and it may well be extended again. And they've been announcing these extensions at the very last minute at the end of the month. So if you go to the ESD website, which is esd.wa.gov, at the top of the page, there's alerts listed there. So that's a good source to check in with that if you're concerned about whether the job search is required. But if you're doing a job search, this is the thing, whether you're doing it as an optional act or not, make sure that you apply for jobs that are suitable for you and safe, and not to just apply for any job, because then if you apply just for any job and then you have to report that you turned down a job, it can be messy, and it's better to avoid that. If you apply for a job that you do think is suitable and it turns out not to be safe or suitable, you have to report that when you do your weekly claim. But right now, the job search is suspended. Up until October 1st.
Thanks, John. I do want to mention there is a question in the chat about a member of a Facebook group who is on extended benefits. And as they're filing for extended benefits, they're being asked to enter their search requirements. So we do want to confirm that the search being held in abeyance, being suspended at this time, does apply for extended benefits applications as well. It applies to everyone. And you can answer that question honestly. If you're not searching for work, you can say no, and it should not impact your ability to qualify for benefits. I will also tell you that in a number of hearings that I've been representing claimants at, the judges are asking about if claimants have been searching for work. Some judges will acknowledge that the search has been suspended, and they'll say, well, have you been searching anyway? Some judges may not even acknowledge it. And I prep the claimants and advise them to answer honestly and truthfully, as they always should. But just so you're aware, the question may still come up. Partly, I think it's technologically already ingrained in their system. And also, if you go to a hearing and the judge asks, just be prepared. But as John said, towards the end of every month, keep an eye on the ESD website, keep apprised of our weekly webinars, and we'll keep you posted on the status of the job search requirement. Okay, Erin, do you want to jump to another question?
We have another question about substitute teachers. It looks like there's kind of an odd technical setup with SAW where substitute teachers are getting paid for professional development, but they're not actually working any hours right now. So on the SAW account, it will ask if your employment ended. If they say no, but it won't let them put 0 hours, but they're working 0 hours. If they say yes, then they have to choose between being laid off or fired or quit, which none of the above are accurate. So how would you say that they should address these questions?
This is a good one, and this type of situation has come up recently with people. For example, there are some physicians in the state who have been getting some supplemental payments from their employer. They're not working and they need to report it because it's income from the employer allotted to a specific period. It's hard to say because these systems are set up with very common scenarios in mind. People are unemployed, or if they're partially employed, they ask, did you work? And if you say yes, then they ask you how many hours and how much you made. And usually that's not hard to do. You know, I worked for 10 hours and I made, uh, I was making $20 an hour for 10 hours. I made $200 this week. You put that in, and then they calculate your benefit amount accordingly. It's not 100% deduction, but a partial deduction. And it's problematic when you're getting compensated from an employer essentially for not working, but there's not really a category. I've been told, they ask about whether you're receiving workers' comp, they ask if you're receiving crime victims compensation, they ask other questions, but they don't quite handle this. I honestly don't have a good answer. I do know that there are people at Employment Security, some policy people who might be able to either answer the question or set up a meeting. I'm going to put a person's name in the chat if you wanted to email them specifically. I know someone else in another field who got a response with him. His name is Dan Zeitlin, and either you or maybe a group of people, substitutes in the same position, can attempt to set up a meeting and see if you can get some answers on how to handle that. So it's Dan Zeitlin, who's a policy person at ESD. But it shows the failure of the system in the sense of it being designed, and even this issue of asking if you're looking for work, that's been very confusing for people, because back when they announced the rule change in March, I was led to believe, or I had heard, that they were going to change it on the website, but they did not do that. And it may be a software issue of, being very difficult to do. The ESD website is very, obsolete software, so it might be hard to do. But, these things create a lot of confusion, but the income should be reported. And I think that when in doubt, if you can't report something in the weekly claim in the regular way, you can always use your SAW account or e-services to send them a message with it, because then you're reporting it and you're covered. And if it comes up a question in the future, then that should help you.
Okay, so we have another question. There's an individual who's been filing a weekly claim, and it's asking them if they've started training or schooling. She wants to know if that applies to the couple of extra classes that she's taken in a school district.
Well, if it's part of your job, then I don't think it's relevant. Like, it's like the training anybody receives on the job. If it's sort of outside education, it needs to be reported. The rule, and there's some terrible rules in unemployment, and this is one that's bothered me a long time, is that if you're in school and collecting unemployment benefits, you have to be able to say that you're willing to adjust or drop your classes if you're offered work that conflicts. And there's a certain absurdity here that if you don't have to look for work anyway, why are they concerned if you're not available because you're in school? So that's completely absurd, but it's the reality of the rule. So the safest and best thing to do is to answer the question correctly, that you are in school, that you are taking classes, and that when you're questioned about it later, say, if it's true, of course, that you're able to adjust your classes or drop classes accordingly if work came into conflict with this. And I've had a few questions about this recently, and it just shows the absurdity, because people are not being offered work, and education is a positive thing that we should all pursue. But again, these rules are in place, and they won't be changed at any time soon. So it's best to keep your claim as clean and simple as possible.
I would agree with that, John. I think what I've learned from some claimants is if it is ongoing training and education related to your current employment, or whether you're a layoff or you're standby, then it's not the training, traditional training that ESD is inquiring about in terms of a separate training certificate program or an additional area of advanced learning and knowledge that you're trying to achieve for yourself. So I would agree with that advice. Erin?
It looks like we have one more question. If you guys have questions, please continue to put them in the chat. This one is going back to the issue of the appeals, but I think also potentially adjudication. Do you know if there are any pathways available to resolve the issue of being in adjudication for indefinite periods of time, but then also relative to the wait times to get your hearing and have your appeal passed off to OAH from ESD?
Well, again, we're getting many, many calls on this. I would first call the hearing office to make sure, Office of Administrative Hearings office in Spokane, and their website is oah.wa.gov, and it would be the Spokane office. There's an 800 number. They'd find out, first of all, if they have it and if it's going to be scheduled. And then I would follow up by calling your state senator and your state representatives and go to the Washington State Legislature website. You can also contact the governor's office, both by phone and by email, and contacting Senator Murray, Senator Cantwell as well. Also, you can contact Unemployment Law Project individually. We can attempt to contact ESD. When we contact ESD, the results have been mixed, from no response to a very successful outcome to an answer that doesn't really answer the question, or maybe just a note saying your claim is being accelerated or escalated, which really doesn't say much. It doesn't give any time. So, but it's better to do all of these things than nothing, and to move it ahead. And I think when you're contacting, whether it's your state senator, your state representatives, the governor's office, or your federal representative, or Cantwell or Murray, you are letting them know that there's a big problem with the system as well. So they are, I'm sure, very tired of getting these calls. But if we quit calling, they're going to assume that they'll buy the ESD line that it's all been resolved and Operation 100% was a success. And declaring victory might be a good public relations move, but it really doesn't show what's out there.
That's right. That's great, John. I would also agree with that. And I would just add to use your best judgment. If your situation is egregious and really dire, and it's been 8 weeks, 10 weeks, 12 weeks, and you've been unable to receive any benefits, and your financial situation is in really dire circumstances, reach out to all of these resources that John has highlighted, and certainly contact our office. I would also say if your case seems like a no-brainer, if you were legitimately laid off or you should be entitled to benefits and ESD has asked for your identification and you uploaded it and then they denied you or you haven't heard anything, and it seems to be either a technological issue, an administrative matter, or something that, in normal circumstances should have been resolved fairly simply, reach out to our office to see if we can assist you, because those situations, we do encourage and advise claimants to file for an appeal to preserve your due process rights, but we do also let ESD know that this shouldn't be an issue for appeal, and it's a matter that could potentially be resolved fairly quickly.
So I went ahead and I put all of the different contact information that Banaz and John referenced in the chat. I also included OAH's phone number to their Spokane office, so you can give them a call that way. Otherwise, it looks like we don't have any other questions. So I think that we can go ahead and start to wrap up, unless anyone wants to get one in last minute. Otherwise, thank you all so much for coming. And
thank you.
your day.
All right.
Thank
Thank
so
you.
much. Thanks for
Bye-bye.
joining us. We look forward to seeing you next week. Reach out.
Oh, it looks like we do have one last minute question. Okay. Do you have any more information about applying for the PEUC, which is the extension of the UI? The questions seem to be different than the typical questions you would see for other applications.
In terms of any more information, I'm not sure what our participant is looking for, but I do know the participant, so I will reach out to her directly. And the PEUC, just for clarification, is an extension of the benefits timeline. It's the pandemic. It's an extension of when a claimant expires their 26 weeks of benefits, they can apply for the extended benefits and future extension of benefits, which is 13 weeks, and I think it goes up to 20 weeks total. That is the PEUC. It's not an additional source of funding. It is an extension of time and the ability to continue filing for claims. But I'll reach out to our participant directly. Thanks, Erin.
Thank you so much, everyone.
Thanks, everyone. Bye-bye.